Chair, over to you.
Okay, let's call this meeting to order. Do we have a quorum of board members present, Kathy?
Yes, we do. Madam Chair, all board members are present.
Okay.
And I'm going to go ahead and share my screen now. Yeah, that's not it. There we go. Okay.
Okay, so you all have the agenda in front of you. It is 8:30 on Wednesday, December the 9th. The meeting's been called to order. A quorum has been established. So we will proceed with this quarterly board meeting. The first item that I'm responsible for is the reading of the conflict of interest statement reminder, which was an executive order number 127, stating that at the beginning of each meeting, the chair shall remind the members of their duty to avoid conflicts and appearance of conflict and inquire as to whether there is any conflict of interest or appearance of conflict with respect to any matters coming before this board. Individual members must make a diligent effort before taking any action, including participation in discussion, to determine whether a conflict or appearance of conflict exists. Individual members have an affirmative duty to inquire of their business associates, families, and close friends of any issues that may come before this board. If a member has a question regarding his or her particular situation, that member should ask direction from the chair or in the event of the chair's unavailability by the vice chair. Having read the conflict of interest reminder, does anyone have any conflict coming before this board today? Hearing none, then we will move forward. Kathy has read the thank you note from John Silverstein, appreciating both his 43-year service as our counsel and the artwork that was donated with funds that were voluntarily given by previous board members and John's attorney's office. The public notice of this meeting has been published both on our website and with the Secretary of State. Notice of this meeting has been mailed and emailed to all appropriate government officials, and public members have been notified that they may join us today via Zoom, which has been established. I refer you now to our September 2nd minutes. You should have those in your possession. At this time, we need to review those and ask for any discussion and possible motion related to the September 2nd minutes.
This is Leslie. I move that we accept the minutes as is.
Second.
The motion has been made and seconded. I'm sorry, who was the second?
Crystal.
Crystal. So Leslie motioned, Crystal seconded to adopt September 2nd minutes as written. Is there any question or discussion about that? Hearing none, let's have it put to a vote. All those in favor of adopting the September 2nd minutes, let it be known by saying aye.
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 Those opposed? Anyone abstaining? The motion carries. The next order for business is summary of applications. This is very exciting.
Of which there are none.
Yeah.
Of which there are none. You know, for those of you who've been on the board a number of years, you're accustomed to having to look at different requests, and particularly
I was surprised.
It was a lot less reading for review.
yes. So tell us why this is so nice, Kathy.
So as you all voted to adopt some temporary rules that would enable the alternative approval pathway for exam eligibility, that applies to CAPTE graduates, and that also applies to 100% of special accommodation requests. So during this period of time, this last quarter, there is an October exam that's already passed, and then upcoming, you've got a January exam. But anybody that wanted a special accommodation who had applied after a certain period of time would go to the Federation for that. Similarly, exam eligibility after a certain period of time goes to the Federation. It would be foreign educated applicants who are not substantially equivalent or have another issue that needs to come before the board. And we didn't have any of those, nor did we have anybody that answered any of the application questions with responses that needed to be reviewed this time. So you're right, it's a game changer. But I will also say the board staff, and you know, I'm going to take that as a whole because it is a team effort, but primarily the licensing specialists have really worked exceptionally hard because, you know, there was a line in the sand at which AAP took effect, but everybody who had applied prior to that time is still going through the old process. So they're straddling this line of having to do two different processes at the same time, coaching applicants, coaching schools through it, through Debbie and her leadership, and then coordination with the IT department and Cindy. Everybody has a part to play in this process, but I think you can see the results of certainly regulatory flexibility, which brought this up, and you are making applicants more efficiently be able to access that exam, and then, you know, you'll see the final result for the review of the actual licensure approval. So that's that story.
Thank you, Kathy. I think we can all collectively say thank you to the staff and to David Nall for making our board member review process that much more efficient as well.
Absolutely. Excuse me.
Okay, next up we have David Gadd giving us the attorney's report.
So since our last meeting, if you'll recall, we had a flurry of legislation from the General Assembly at our September meeting, and since then the General Assembly has been out of session, so there's not anything really new. Attached in your ClickUp agenda is a copy of Session Law 2020. Let's see, I think it's 97. And if you want to see the pertinent part of that, you have to go to page 49. It's a pretty long document. But what that is, and we discussed it at the last meeting, is that's the portion of the law that allows and I guess requires licensing boards to do just a few things to try to ease the burden of what's going on with COVID and their licensees. So just real briefly, delay the collection or modify the method of collection of fees, fines, late payments, delay the renewal dates of permits, licenses, and other certifications and registrations, and delay or modify any educational or examination requirements implemented by the agency pursuant to its rules and statutes. The law requires that the board issue or submit to the General Assembly some reports, which we've done. I think we've already done 2, and the law expires when the first of two things, either the first of the March 31, 2021, unless it's extended by the General Assembly, or when the governor rescinds the state of emergency executive order, which was Executive Order 116. So we're still under this, and what it essentially requires us to do is exercise regulatory flexibility, and it goes on to say to the maximum extent practicable in order to protect the economic well-being of the citizens and businesses of the state, while also continuing to protect public health, safety, and welfare. So this has been around since the summer, and later on in the agenda, I know we have several things to go over with you about what the board has done to comply with this, and what has been submitted to the state as far as our records go. But there's really been no, since the last board meeting, there's been no new legislation from the General Assembly like there was last time. There was a flurry last time. The governor has issued some executive orders, none of which have been as applicable to us, I guess you'd say, as they were early on. And most of you are already aware of this. They've mostly just been extensions of existing orders and slight modifications of how to deal with COVID related issues, like the one you saw that came out yesterday with that placed the we went back, I guess it was a modification of phase 3. We went back to a curfew and more formal restrictions between the hours of 10 p.m. and 5 a.m. So most of the governor's orders have been just extensions of existing orders and slight modifications based on the current issues and situations regarding COVID. So that's it for new laws. As far as the state level, on the federal level, there has been a push from several members of Congress that's basically a reaction to the North Carolina Dental Board case. Let me pull that up here. So just as a reminder, the North Carolina Dental Board case was an antitrust case where the federal Supreme Court ruled that the North Carolina Dental Board couldn't place anti-competitive restrictions on businesses that did teeth whitening, and that the dental board had folks on their board who were actively engaged in the practice of teeth whitening, and therefore it was an anti-competitive practice to essentially prohibit that. So what this new law will do, and it hasn't been enacted yet, but I think it's going to be reviewed in Congress as soon as next month in January. But what this new law would do is it would provide protection, and how this relates to you as a board member is it would provide protection against any sorts of damage claims by plaintiffs against licensing boards. It would provide protection from you as board members, as long as certain things have happened as far as how the board members are appointed and how they act, which we would all be in compliance with. Examples of that is we would have to be, you would have to be appointed by either the General Assembly or the governor. You would have to give opportunities for complainants to come to you and tell you why they are aggrieved, and there would have to be an appeal process. Anyway, as long as all those steps are followed, which are already built into our rules and laws, then the federal government would pass this law that says you as board members are not going to be on the hook for any sorts of damages if you act within the scope of your work on the board. as long as there's not anything negligent or outside of that scope, then you would not be on the hook for damages. I haven't heard of any cases where that has happened. It must have happened somewhere to bring this to the forefront, would be my guess, but I haven't heard of that, of a board member being held liable for anything regarding an antitrust case. But anyway, I'm not aware of anything that would hold this up. So I think this will be in place, and it just gives you as a board member protection against, that potential.
If I might add in, this has relevance because you're going to consider approval of the directors and officers liability insurance renewal, which has significantly increased. And, I don't know that we want to choose to go without it. This law hasn't passed yet, and anything can happen. But that was why we purchased that very very expensive coverage, so that the board and its members in doing the business of the board were covered in case of some kind of litigation.
And there's probably some overlap there. There may be some parts of we can look at the policy, but we probably don't want to get rid of it altogether. But there may be some parts of it that we don't need if that law passes. Okay. Back on October 1 through the 3rd, I attended a FARB, Federation of Association of Regulatory Boards seminar. It was a seminar that offered, it was primarily for lawyers, but it offered continuing education credits for those lawyers who represent licensing and regulatory boards. And it was offered to anyone in the country. So it wasn't specific to North Carolina, and it wasn't specific to physical therapy. But what it did was it gave me kind of a broad view of what other boards are facing in all different professions. And just a quick update on those. There were some fairly interesting topics. This was kind of back in October, and I guess still now, a lot of these boards were still struggling with how to deal with public meetings via Zoom and other electronic means. So that was a lot of time was spent on how boards are dealing with that, and some states don't require the YouTube streaming like we do, and some states do. Some states still allow or require that the board meeting be open to people to come in and sit certain distances apart. So there's different ways that it's being handled, but at the end of the day, I was fairly surprised that most boards do pretty much exactly what we're doing this morning. So we talked about Zoom meetings. They did talk about universal licensure, which I found was interesting, and comparing that to how our compact would work. Universal licensure is different than the compact in that it is up to not so much individual states, but individual boards of the states to figure out whether or not they want to honor other states' licensees. And it's completely left up to licensing boards. And it seemed to me that it was compared to the compact, it was very disorganized. And I think that's probably the biggest drawback. The states don't have to enact the same legislation like they do with the PT compact. So it's kind of all over the place, but there are a handful of states that have either already enacted the universal licensure legislation for various boards, or pending legislation just for various boards, and they do it kind of piecemeal. It's not for all licensing boards. They just, if one board is interested, then they do it one at a time. some of those states with pending legislation are California, Georgia, Iowa, Ohio, Montana, Virginia, and Washington. So that's maybe 6 or 7 that are looking at that right now. I haven't heard, Kathy, you may know, but I haven't heard any push from any North Carolina licensing boards for universal licensure recently.
No. Based on past history, I would say that most boards wouldn't support it, at least the healthcare boards.
Had a fairly interesting case law update about just various recent issues with regulatory boards. One of them that I thought was probably the most interesting, and you probably heard about this in the news, was the dentist from Alaska who was working on a patient while on a hoverboard. That was all over the news when that occurred, and what came out in the news, and I don't know that the backstory ever came out, at least I didn't hear it until this seminar, was that he received 12 years in prison for this act and couldn't practice, be relicensed in dentistry for 10 years after that. So essentially a 22-year ban from being licensed by his board. What the folks at the seminar pointed out was doing the treatment on the hoverboard wasn't the reason for the jail sentence. He had all sorts of issues involving Medicaid fraud and administering anesthesia to patients without obtaining consent. So that was probably the most interesting case that we went over. They talked about specialty certification, which we don't deal with our board, but that's just I know with the state bar, you can practice a certain number of years, take an exam, and be a certified specialist in a specific area. Talked about that a good bit. One thing that I thought really applied to us was the topic of overlapping scopes of practice. The general gist of the topic was it happens all the time. There's lots and lots of overlap between boards, and typically when there is a lawsuit, as we're familiar with, courts, what they typically do is leave it up to the boards to define their scope of practice. And if there is an overlap in scope of practice, then they allow that to occur. And there was a 2018 New Mexico case where the New Mexico Society for Acupuncture and Asian Medicine filed a suit to enjoin a private company from teaching dry needling techniques to physical therapists. Similar to North Carolina, the PT board issued a letter stating that dry needling was within its scope of practice, and the court in New Mexico deemed that the PT board has that authority to determine what its own scope of practice is, and allowed it. Finally, talked about some executive orders across the state, across the nation, and how those are put in place and why they are allowed. And it seems like some of these executive orders are they have elements of lawmaking, but there was just detailed discussion on how what authority governors and the president has to make an executive order, particularly in light of COVID. And the executive orders are essentially based in statute, that the statute allows, statutes and laws allow them, the executive branch, to manage and operate the government. And they're doing those duties by enacting these executive orders. And if any party believes that the executive branch has overstepped boundaries and is enacting laws by these executive orders, that's when that's when the courts can step in to determine whether or not it's within the authority of the governor or the president to do that. And we've had several of those lawsuits here in North Carolina regarding the most recent executive orders. So that is my overview of the FARB meeting. And the other issues regarding Session Law 2020-97. So I think that is my update for now.
Did you
Madam
want to
Chair.
talk about the medical examiner?
Oh, yes, the medical examiner update. So at our last meeting, we had the discussion about PTs potentially being added to the statute, which would allow them to be authorized medical examiners. And there was some discussion with the medical examiners about how far that should go and what other professions they should include. And in reaching back out to Brad Bretcher, which is the lawyer for the medical examiners, I found out that about the same time as our last meeting, he moved from the Board of Medical Examiners, or the Office of Medical Examiners, to the Department of Public Safety with the state, and the attorney position there with the medical examiners is vacant. So I don't think, not only do we not have anybody to provide us with the information and the updates that we need to be able to pursue this, there's nobody else to go to right now. They're working on filling that position, and I've sent Mr. Bretcher an email, even though he's not in that position anymore, asking him to, if he can, if you know some of the new person, to provide that information. So we'll get it to you as soon as we can. So that's kind of put on hold at the moment until they fill that position and can kind of follow up with that. But to my knowledge, nothing since his departure, nothing new has happened on that front, and we'll just have to keep working on that one.
Thank you, David. Are there any questions from a board member for our council? Hearing none, I think that because closed session is an hour away, we'll skip over closed session right now and go to the executive director's update.
Thank you. If anyone has had any updates to their address, their name, their contact information, or contact phone numbers, please shoot us an email, let us know somehow so that we can update this list. So just check with the attachment that's with the agenda here to see if you need any updates. The licensee count as of November 6th, and this is, about a month ago now, but what I want to draw your attention to is the rate at which the licensee population is increasing. And, it's 2.80, which is down from, our high of like 4.9. This was expected as programs sort of stabilize, and they've done the increasing of the numbers of the cohorts, and then these new programs have come online. We're waiting for one PTA program to obtain its accreditation, but I believe that this is going to be either our steady state or it may go down a little bit further. But you can see that we're pretty close, and I think we've actually gone over the 14,000 mark in terms of total numbers of licensees. What typically happens during renewals is that we lose 400 or so, and then it goes back down under, and then later in the year we regain that. So you can also see these line items here: compact privileges, temporary permits. And the temporary permit in this case is military. It's not the temporary exemptions that we're talking about, but so it's steady. Obviously compact privileges last year at this time, we had only been doing it for several months. So that's the difference there. Does anybody have any questions about the licensee count?
I have a comment that I had asked about last time, and that is when it has the exam failures, we believe that's cumulative, and wondered if that could be reported by year instead, so it would be more meaningful.
I am sorry that I did not do that, and I can certainly ask Greg to see if he can update that. Debbie, I don't know if you have any anecdotal information you want to share about this year's exams. You're on mute.
I don't have anything at this time.
Okay. One thing I will say, Jamie, is that this can go up and down based on what's happening with the Federation's modifications of the exam. They did push back. I can't think of the proper term that they use, but they reevaluate the curriculum periodically, and then they change the questions and the content of the exam based on how the curriculum is evolving over time. And so when they make a really big adjustment to the exam content, there tends to be a little bit of a dip, and then, and then it kind of comes back up. But, so the information is useful, just you have to take it into context with that as well. And heaven knows what's happening during COVID with people taking exams at different times than maybe they were expecting to. Okay. So I provided you with an update on the goals that, oh, wrong one. That we had discussed at the September meeting, and this is still the wrong document. Anyway, my apologies. I had uploaded a document that gave you an update on what the board staff has been working on, and if you scroll into it, you can I tried to color code it a little bit, what's been completed, what we're still working on, and a lot of this is ongoing, but almost everything has been at least started, and we continue to modernize, and I think really gaining efficiencies, and I think the most obvious thing to a board member is going to be that using of SharePoint to do the application approval. So but this is just an update for you on where the staff stands on these overall goals that the board approved back in September. Just a little update on renewals. Debbie may have some additional items that she's going to share during her report, but under the implementation of things that we did differently in 2021. Some of this is response to regulatory flexibility. Some of it is just, it was time from a modernization point of view. We are now accepting payments, all contactless payments, no checks, no paper.
Yay.
Yeah, yay. E-checks and Cindy, I don't know how Cindy feels about all that. She gets to manage all of the incoming, which at this time of year is pretty significant. Okay, good. Thumbs up. That's what we're getting over there. So we implemented the e-checks. Thank you, David Edwards, a long time ago. Idea whose time has finally arrived. There is a much smaller processing fee for use of e-checks than there is for credit cards. And that has everything to do with what the credit card companies charge us, because we recoup the cost of that from the licensee. We have, thank you to the IT department, our contractor Suba and Greg for implementing the National PT MDS. So excited to see the outcome of that. That aggregated data, and Sheps is already prepared for us to provide them this new information. And then of course, if the Federation is interested in it, using it for their research institute, they can ask for it and we grant them permission to use that. We changed the notifications on the pre-welcome page to let everybody know what these changes were before they started their renewal. We are saving every single field of data separately for this year, and we will continue to save it separately going forward. That has significance because previously the admin tool kind of overwrote. It only changed the items that the licensee changed in answering those questions, and that isn't quite enough to be able to do. We needed to save them all separately, so we're doing that now. Very different is we are no longer accepting any paper renewals. And so while it's a small number, but if someone answers yes to one of those application questions, you have those same application questions on the renewal. And if someone answers yes to those questions, they're put in a holding pattern. And then I go in, myself or Debbie goes in, we look at it, we make sure that they make a personal statement. If there are court documents or anything like that, that they have to provide, we get those before we release the hold and allow them to go through. Now, so far, the other known quantities, historically, folks that had some disciplinary action within the last 2 years also had to answer yes. And so as long as they are providing us the information that that we need to be able to know that we already knew that, or they had taken action as they were supposed to, we can move that right along. Again, no paper, very efficient process. It's working so far. And thanks to Greg for reprogramming that. Let's see, we have updated some fields in the renewal progress report. You all probably only seen one of those so far. And then because of the rule change, Greg is not staying up till midnight to shut this thing off. It's the end of business. How reasonable and modern. And this year, because January 31st falls on a weekend, we are going until the 1st. So, you know, we've done some significant changes and modernizations, and I think that, you know, at least as far as that goes, haven't gotten tons of feedback or questions. Debbie probably has a different perspective based on what she does. Let me just jump over to the renewal statistics. What I have found fascinating from the very beginning is the fact that Ben started collecting this, I'm going to say back like in 2011. And so we kind of track it around the same dates every year so we can compare it. And if you look at December 7th of 2020, and 20.14% have renewed, and then you go down to December 7th of 2019, 19.06 have renewed. This stays consistent every year. It just is fascinating. You know, my only fun with numbers. I don't like numbers, but this is fun with numbers. And so we're on track. I think sometimes we feel like it's a little slower. Sometimes we think it's faster, but when we look at the actual numbers, it's kind of right on target. You know, at the end, we will see if people don't renew for whatever reasons, because they're not working or something else. But right now we seem to be kind of on track. Okay. Oh, no. I'm sorry. Get back in there. Well, I lost my screen share. Hang on just a minute. Okay. So the next item that I wanted to talk about, I'd like to save this till the end because there are maybe 4 things that we need to talk about at the same time. Related to Session Law 2020-97 that David talked about, we needed to consider whether the board would like to take any additional action regarding regulatory flexibility in those categories that session law speaks to. So we'll do that after I finish at the end, when I finish the rest of this report. Excuse me just a minute. I've got it. Yeah, thanks. As we continue modernization of the office and continue preparations for transition planning, I wanted to ask the board if they will approve my ability to continue to make decisions related to staffing and things that are needed to be outsourced. We haven't reviewed it yet, but the payroll audit has brought up some important issues that we need a payroll vendor that is going to effectively keep us compliant with the retirement plan and keep us appropriate in terms of the taxes that we're withholding, and then our communications with the state. We already were outsourcing that, but there may be some additional features of the financial bookkeeping that we need to outsource as well. And it's not in a line item on the budget, but I need the flexibility this year to be able to make these decisions, and to as our office process is modernized, the types of staff that we need also need to modernize with it. And so I would like to ask that the board allow me to make the financial decisions relating personnel and outsourcing of functions as I need to this year, which would involve one position. And this is probably between $50,000 and $60,000 a year. I don't know that I see it taking place before July of 2021, but there's a lot of planning that has to go into it. And without the ability to do that prior to the next budget cycle, it hampers my ability to make those plans and implement them. I'm asking for the board to make a motion that the executive director has the authority to go ahead and make appropriate decisions relating outsourcing and adding of another staff member to handle some additional administrative and financial functions.
I'll make a motion that we do that.
Second, Leslie.
Okay, motion's been made and seconded, made by Jamie, seconded by Leslie, that we give the executive director the authority to make a hiring decision. And do we need to set a max budget on that, Kathy?
I think that that's reasonable. I have not done enough homework at this point to know exactly what outsourcing these functions is going to cost. But I'm going to say between the outsourcing and the staffing, I would probably say a total of about 80,000.
Okay, so I think that we could add the budget to the motion, that would be appropriate. Is that okay with you, Jamie and Leslie, to cap it at 80,000? Okay, any other discussion or questions for the ED? Hearing none, let's take a vote on this motion to give Kathy authority to outsource and make a hiring decision with a cap of $80,000. All those in favor of let it be known by saying aye.
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 All those opposed, no. Any abstaining? The motion carries.
Thank you for that. And I will keep the board updated as this progresses. The next item on the agenda, which you didn't get an opportunity to use at this board meeting, but may be useful for you in the future, and it's always going to live here and click up and can always be sent to you. But as you are reviewing applications for licensure, and there are those answers on the questions in the application form, if someone answers yes, we are providing a rubric for you about how to think about those questions, and not only how to think about it, but also how it is handled in the office, so that you know that there has been some amount of scrutiny and analysis on these things prior to it ever getting to you. And we certainly welcome your questions, as you're reviewing applications, but also for those that, are newer to reviewing applications, or if you haven't seen a yes answer to one of these questions at the top, it kind of gives you more information about how to think of it. So just to give you a little orientation here are the questions that are asked on the application. And so from there, if any of those are answered yes, then you move to the next stage, which is additional documentation needs to be provided. That is provided to the staff. And then depending on what it is, the staff either reviews it and can move it forward, or we send it to David Gadd, and then David Gadd advises whether it can be signed off on or whether it needs to go to the full board. So, you may or may not see it while that decision is still being addressed. So then step 3 is that the attorney will review it, and then the board may review it as well. But when you are looking at it as either a board member or as a full board, here are the 2 statutes that relate particularly to criminal history and how you want to go about thinking about these things. So in 93B, which is the occupational licensing statute in North Carolina, is the seriousness of the crime, how long ago did it happen, how old was the person when the crime was committed, what were the other circumstances surrounding the situation, how does what they did relate to the actual practice of physical therapy. And while sometimes you look at some of these things out of context and you think, oh my gosh, would you want a licensee to have that in their background? Well, it didn't have anything to do with the practice of physical therapy, and so you can't really look at it in that kind of context. What has that individual done to remediate? Then there's also the consideration of has anything similar happened in their history, and have other people been willing to speak on their behalf, et cetera. And then you look at our Practice Act, and it's sort of a duplicate of a prior version of 93B, but that also gives you some guidance about how you want to look at it as a board member. And that's primarily for the criminal history. And for those of you that have been on the board for a period of time, as you know, some people have come before the board and they sort of state their case. The board asks questions of that individual and then makes a determination about whether they believe that person could obtain a license, or whether they need to do some additional remediation or take some other action prior to being approved for licensure. So, for those of you that had an opportunity to take a look at this ahead of time, does anybody have any questions about any of this? We can talk about it at another point when you actually have an application to review. I would like to give Debbie Reagan credit for putting this together and making it, a process that is tangible here in written form, as opposed to us just saying it to you and asking you to remember. It gives you a little bit more information here. So thank you to Debbie for that. Under the scope of practice area, what I have provided to you here, as opposed to just putting it in the section where questions that were answered by the executive director or the staff, is that the APTA NC current president, Mary Kay Hanna, asked for information about the history of the Imaging Practice Act language and rules over time. And they want to know how that evolved, what potential opposition there had been historically. And we were able to provide the documents that we have in-house. Again, Debbie pulled those together because we keep copies of every iteration of the Practice Act and every iteration of the rules. Debbie was able to pull that information together and we shared it with them. I will say that, as you may know, nationally, there are some states that allow physical therapists to order x-rays and other imaging kinds of reports. We've had musculoskeletal ultrasound questions brought before the board and other kinds of imaging questions. And so I think this is going to be a topic at some point going forward, but I wanted you to be aware of that. Also because APTA-NC in their virtual continuing ed offerings had that musculoskeletal ultrasound course. Because they didn't choose to bring this before the board as a question for them to consider, you all to consider at this meeting. If you had signed up for that and hadn't yet had a chance to take it, I know it's available until I believe it's the end of January. They did that on purpose so that people could count it in their continuing competence to either in this reporting period or the next. So that was really great. And so if you hadn't done any review or gotten information about musculoskeletal ultrasound, that may be a good thing to use to prepare yourself for just further discussion we may have at a later point. And so now moving toward our discussion about regulatory flexibility, this report was an interim report that was sent by January 1st, which was the date that the interim report was due. And in that report, we hadn't really made any additional changes since the October 1st report was made, but here are the items that I think that we need to consider at this meeting. And let me just list them out for you. Potential elimination of examination retake fees, changing of the exam eligibility temporary rules, which was the AAP approved rules, into permanent rules. They're just temporary right now. We have 270 days to make them permanent so that we can continue with this streamlined process. We need to consider any modifications to the renewal fees for fiscal year 2022. Well, it's not, it is fiscal year 2022, but it's the license renewal that will end January 31st of 2022. And then lastly, modification of any licensure processes from paper to electronic. And we've really already, the staff is taking care of that. But the questions for the board really have to do with exam retake fees. And in the rules section, we'll work on approval of temporary rules to change into permanent rules, and then the renewal fees for fiscal year 2022. So
Matthew, why are you wanting to eliminate the exam retake fee?
Great question, and let us tell you. So with the move to the alternate approval pathway, the applicant who might not pass the exam on the first go round or a subsequent go round formerly had to come back through the board to have the board make them eligible. That is not going to happen anymore because FSBPT is going to make them eligible. Therefore, there is no additional work being incurred by the board at every subsequent exam retake. And so, I think that fee was originally implemented when the board was having to go back and, do some additional paperwork related to each subsequent exam attempt. And we aren't incurring expenses related to that anymore. So, it becomes an issue of why are we charging for something that, we really are not, we don't have a work product related to it. Now, it is in the Practice Act and it's also in the board rules. So I'm not going to recommend that we change that. It's just what I'm recommending is that we don't charge it to anyone. And while you all are still going to need to approve exam eligibility for foreign educated applicants who have to retake the exam, this is very, very, in the great scheme of things, it's a very small percentage. And I'm going to say 1%, less than 1% of the exam applications that you have to look at, or licensure applications totally. It's such a small percentage that I think that can be absorbed into, the fees that we already charge for application review. Now, if we, for some reason, decide that we are not going to do AAP in the future, something happens, that process doesn't become as effective as it currently is. We haven't removed it from the rules or the Practice Act, but and we haven't really had that specific part of the conversation with David Gadd yet, but we may need to remove it from the rules. But we would have the ability to reinstitute it, at least within the current year and a half, until we go through a rulemaking process again. So does that answer your question, or do you need additional information about that?
That answers my question.
Very good. Are there any other questions about that? Okay, so I think we need to take these sort of one at a time. So what we need is a motion to no longer charge exam retake fees for applicants who need to make subsequent exam attempts.
Move that we, now tell me again so I can get the right words.
That we no longer charge exam retake fees for applicants who have to make additional NPTE attempts.
Kathy, can I say something real quick?
You may.
Since the statute and the board rules specifies that there is a retake fee, maybe the motion should be worded in such a way that something like, so long as we're using AAP, the retake fees should be 0. And that way you're not saying no longer, and it makes it look like it flies in the face of what's required by the statute.
Thank you.
Sure.
Would the maker of that motion accept the amended motion language?
I do.
And do we have a second on the motion?
I'll second.
Who was that?
Crystal.
Crystal.
Thank
Okay,
you.
we have a motion by Pearl and a second by Crystal to waive the fees, the retake fees, because of the AAP process. Is that right, David?
Yes, so make the fees 0 as long as AAP is in place and we're using that.
Right, that's the motion. Any further discussion or questions for David or Kathy? Go ahead. Any further questions? Hearing none, we'll take a vote on this motion. All those in favor of the motion, please let it be known by saying aye.
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 All those opposed? And anyone abstaining? Okay, the motion carries. Thank you. And
Okay.
then, so that covers AAP from, we didn't really address it going from temporary to permanent.
That's going to happen in the rules section.
Okay, so we don't need to vote on that as a motion now.
Yeah, no, we can wait and do that during the rules section.
Okay, and what about all the paper applications to electronic?
That is happening anyway. I mean, I think the board has approved the goals and priorities, of which that is one. So, you know, it just enables us to say that we are gradually making a paperless system as part of.
And I want to congratulate our staff and IT department. You guys have done an exceptional job to make this conversion from paper to fully electronic, both in applicant submission, in board review of applications, and in the payment process by licensees or applicants to do. So I just want to put that on the record that you guys have done an exceptional job here.
It's so much easier.
Yes. All the way around.
Thank you for that. I would echo those sentiments. Watching, you know, the staff meet literally daily for months now. I can't remember exactly when it started, but it's been months to make this process more streamlined, seamless, easier, and with the feedback from the board, I think we've gotten to a really great spot, and everybody has contributed. So thank you for that. The last topic, which was something over which I had great heartburn, and that was we had an initial flurry of requests or inquiries, I guess, about whether there would be any alteration of the renewal fees this year. And, you know, while it was anecdotal, there were people that were very strongly wording how many people had lost jobs and been furloughed. And I think the difficulty on the board's end, the board staff's end, is that we had no data to support any of that. And so then, you know, we couldn't quantify it. And, you know, it was based on, you know, anecdotal information that was coming in on people's comments and questions. So kind of concurrent with that, the end of the year financial audit was completed. And we realized that not only have we recouped the money that was spent in the litigation, we have exceeded it slightly. And as a result of that, when we collect this year's renewal fees, we will be in a, you know, a financial position where we may be able to offer a decrease of the renewal fees, like a one-time decrease of the renewal fees for the following year. And I think that those of you who may have been on the board right before the lawsuit started, the prior year we had decreased the fees by $20, again, because the board was doing well financially and felt that that's a way that you know, we could give the licensees you know, a break because the operations didn't require all of that. And then we had the lawsuit which depleted the reserves. So at this point, we are back in good financial shape. And given the hardships that some licensees are experiencing, I would like the board to consider a couple of things. One is if the board would like to reduce renewal fees based on our financial situation, we could vote on that now. So when this was done before, the renewal fees had just gone up to 120 and they were reduced to $100 for across the board. That $20 times 14,000 licensees, which is, about what we have right now. Let's just say for round numbers sake, it's about $250,000. It's a little more than that. If you reduce the fees by $50, it's $700,000. And because renewal fees are the bulk of our income, and our operating expenses have been about $1.5 million, between $1.3 and $1.6 million. $700,000 would be a significant reduction, and we would be using reserves in order to keep up with office operations. So I don't know if, because we are in this year of COVID and the renewals are only partially complete this year, we might choose to make a decision about this in March of 2020, after we see whether there is indeed a big drop in license renewals, maybe because of people not being employed. We could look at the data that we've collected in the minimum data set and look and see, which might then strengthen our arguments about which amount of money we might choose to reduce the renewal fees by. But it would be, I think, important that we go ahead and maybe take a straw poll about whether the board may be in favor of doing some kind of reduction of the renewal fees for 2021, so that I can include that as a board consideration in our final report about regulatory flexibility.
Kathy, this is Leslie.
Yes.
I just have a question. So we need, say, 2021, next a few weeks, and you've already got 20% of people that have renewed. How would that be addressed? Or am I misunderstanding the date?
Yes, and you're right. I should be using the expiration date of the license I'm talking about. So it would be for the license that they are obtaining next November.
Okay.
So that's the one that expires in 2022.
Kathy, this is David.
Yes.
I'm having the hardest time recruiting ever because there's such a great need. I'm not seeing the unemployment issues.
Okay.
I've seen back in March and April, quite a few of my coworkers, about half of the staff at 2 of the facilities I work in were on furlough for up to 2 months, where they were getting reduced pay. Most places are now back to full staff, but some people did lose significant employment and salary during that time. Not anymore, but they'll reflect an overall loss this year. And I know, like in my own case, being PRN and out of work for 2 weeks, no income. I think it would be appreciated and be seen to some as kind of as a recognition that, yes, a lot of us have lost income in the last year. And during that time, there wasn't hardly any PRN work. I mean, being a PRN person.
Kathy, I'm sorry, go ahead, David.
Yeah, one of the programs that, obviously we've had staff that were indirectly exposed and took by precaution, they were out for like 2 weeks. And so part of the CARES Act does allow employers to pay people up to 10 8-hour days and get a tax credit for it in 100% amount. And so that may just be, as a personal note, something to explore as an avenue, but that's just an anecdotal comment.
So Kathy, am I correct in saying we have already reduced licensure renewal fees by $20?
No, that was, it was a one-time thing. So
Okay.
what I'm saying by that is this would not be setting a precedent. It has been done before, and it's in consideration of the situation in which some licensees find themselves, with less work or out of work for a period of time as a result of coronavirus.
My impression is that our renewal fees are very reasonable. And as David mentioned, by the end of the year, nobody's going to be out of work who wants a job. The vaccine should be completed by the end of the summer. So I am not in favor of a fee reduction for 2022.
David speaking. I totally agree with Teresa.
Okay. Does anybody else have any thoughts from any other different setting, what they've experienced in their settings with having to reduce workforce or?
I'll speak up. I was furloughed for 11 weeks. I've been back at work since the first week of July, but our census has not been high enough that I've not worked a full-time week since.
Mm-hmm.
I mean, I work on average 30 to 32 hours a week. And that's mostly because caseload is not there.
Mm-hmm.
We had furloughs and our people just came back, still short staffed, but at the nursing facilities, that's where we're seeing most people are needed, which they're not doing a lot of hiring. And if I at the hospital, then I can't go back to the nursing homes and work, and I can understand why, but they're running short on people because one, their PRN people were from like nursing facilities or other facilities, and they don't want those people
you can't
coming back. So the nursing facilities are falling short, and the hospital still is falling short because a lot of them still have furloughed people in nursing and in therapy sections.
Kathy, if I'm understanding that the bottom line is we're not considering this until November of next year.
Yeah.
So it's not really a pressing point.
It's not, although in light of this legislation and the reports that we need to provide to the state, I think that we needed to have the discussion now. The picture may change by the time we have a March board meeting or a June board meeting next year, because if we learn through collection of our MDS data that 50% of the licensee population is without work or reduced work, that is a data point that I can then give you that's tangible.
Right.
Can we table this discussion and any motion until we have access to that data?
That's what I was suggesting, that we needed to have a little bit of this conversation so that our board is actively considering regulatory flexibility, but that just a straw poll right now gives some idea about what people are thinking, and then we can provide data at the next actual discussion before we make any motion. That's right.
Okay.
This is Leslie. I have a question about an option, and I don't know that this is possible, but is there so here at New Hanover, in my future employer Novant, there have been no layoffs, and we are continuing to hire. So I appreciate what other folks have gone through, and so there's both sides of the coin in terms of that. But certainly the data would support, knowing what the right decision to make is. But is there a way to ask to give that people could apply for like a hardship exemption or something like that, not necessarily an exemption, but say, okay, if you were furloughed for greater than 2 weeks, you are eligible for a $20 discount or whatever. I don't know what it is. I don't know if that's legal or appropriate, but it gives us some opportunity to demonstrate flexibility while also appreciating that not everybody needs that flexibility.
Well, that is really a great point, because when I was having tremendous heartburn over some of these comments that were coming in, I did have a discussion with David Gadd and your chair, Teresa. And David was trying to come up with very similar kinds of, what other options could we do? And so between now and the next time we have this conversation, I need to think about other flexibility options. We anecdotally are hearing that other boards are doing this, but I just don't have good information about that. So that's our job, to bring back some data and what's being done elsewhere. So thank you for that.
When we were paying $100, we were glad with that, and then it went up to it, and we're like, "Oh my gosh, the board has gone up another $20." So I would be in favor of going, dropping it from 120 to 100, and even $20 would help in any way, and the board won't lose so much in the process of that.
Okay.
Thank you, Pearl. Okay, now one other thing, Debbie asked, and this may also be a either regulatory flexibility consideration or a straw poll for a potential rulemaking. The board rules require that if you have obtained a license in the year prior to no, let me back up. If you have obtained a license, let's just say November 1st of 2020, you are required to renew that license. Even though you've just gotten it, you are required to renew it. And there, I think historically, I know I had this conversation with Ben more than one time, there's always pushback on this, always, always, always. And I think, that what seems to be the most reasonable thing we could consider is, do we prorate the fees after a certain date? What I will say, the standard answer, and it's the accurate answer, is that you pay $150 as a processing application fee, or it's not a processing, it's an application fee for the work that the board and the staff do to enable someone to have a license. To continue with that privilege, you renew it during the renewal cycle. And I just think that new licensees have difficulty maybe recognizing the distinction, but there is work that is done to maintain your license as well as to provide you with an initial license. But also understanding that if you've had it for a month and then you've got to renew it, it feels like a lot of fees at the same time. So does anybody have any feelings on either side of that to help us know how to go about considering a rule change related to that?
Kathy, may I make a comment?
Yeah, absolutely.
We get, again, these people that take the exam in October, then they just get their license in November. These are students just coming out of school. We use the same standard template of, again, application versus license. Sometimes for them, it's a hard pill to swallow. We also, when we get in the final component of someone's license application, they've come back from the board, they're ready. We license them regardless of what the date is. So we had, I believe, 5 people licensed on November 30th. Yes, November 30th. And we have an internal policy that beginning on December the 1st, that's when you do not have to renew your license. But these people that were licensed on November the 30th, understandably are going, we either need to improve our education to them about what this is, or potentially maybe go to the rules subcommittee and consider options for, one, educating, and again, prorating the license renewal timeframe several months back. Because we're going to have pushback whenever we make the cutoff. But again, we could then discuss it at a rules committee and see if there are any rules changes that need to be made, and then educate our interested public.
This is David. And
I was gonna say, how often does this happen?
I get considerable concerns about, I just got my license, now I've got to renew it.
Mm-hmm.
So we are explaining, this is your application. The student's going to come back and say, well, can you waive it? No, we cannot waive it. Our board rules now say that our license renewal period is November through January. But again, there is some level of understanding that someone who is an endorsement candidate, a new endorsement coming into the state, that already has a license, gets a license in North Carolina at the end of November and has to turn around and renew it, almost immediately. It just bears looking at.
Can I stop you right there? I'm sorry. Mm-hmm. It's 10 minutes before 10 when we need to go into the closed session because we may have these guests. So can we just pause this discussion and then pick it back up after the closed session? Mm-hmm. Would that be okay? All right. Thank you.
So let's do a 10-minute break. The question is the logistics of coming out of this Zoom meeting and coming back into closed session. I think what I'd like to do is end this Zoom call and end our open meeting so that we will close this up and then come back into the closed session Zoom.
And that's Zoom number 2, right?
Yeah,
this is correct. This is David Nall, and Teresa, you got it spot on. Just end this and join a new Zoom call as if you're starting fresh, and just enter the meeting ID and passcode that Kathy has provided through the board meeting logistics email.
Yes, and I think we need a motion to leave our open meeting and a motion to go into closed session.
And,
that's a move.
Real quick, for the public who may be watching on YouTube, we probably need to give them an idea of when we'll be back on a public session. Are we doing that right at 11?
Well, David, I think we could probably, I did not hear from our second guest, so I'm thinking we could estimate like 10:40.
Okay.
All right.
So if everybody,
we'll be back in public session and at 10:40.
Yeah. So I'm going to call the end of this open session meeting at 9:52, and then we will go into closed session at 10 o'clock and do computer access checks for 5 minutes or so, and then hopefully our first person will join us at 10:15.
Yeah. So do you want to make a motion about the closed session?
I move we close open session and move into closed session at 10 o'clock.
And that's Zoom number 2, right?
Yes, sir.
Okay, just want to make sure.
Second on the motion.
Second.
Okay, so we have a motion to end this open meeting and go into closed session. Motion is seconded. All those in favor, let it be known by saying aye.
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 Those opposed to go into closed session? Anyone abstaining? Okay, so we'll officially adjourn this part of the meeting and leave open session and go into closed session at 10 o'clock.